The next important chapter in business law is remedies for breach of contract. What do you mean by remedy for breach of contract? Breach of contract, it is the breaking the obligation or non-performance of the contractual obligation. It is called as breach. It may be of two types. One is actual and anticipatory. If the one party is not doing his work in the contract, that is called as breach. Then the other party, they are having certain rights. It is called as remedies for breach of contract. That is, it is given by law for the enforcement of the right when a contract is broken. The affected party or the aggrieved party or the injured party can take any one of the following action against the other, which is called as a remedy for breach of contract. They are as follows. Number one is a rescission of contract, specific performance. Number three is quantum merit. Number four is injunction. And number five is damages. Let us see the following. First one is rescission of contract. It is nothing but cancelling the contract by both the parties. Or one party cancelling the contract or treated the contract as cancelled, then it is called as rescission of contract. Or the court itself may sue and the court will cancel the contract. Then a specific performance. Then the second remedy is the other injured party can order through court that the contract must be definitely performed by the other party. That is called a specific performance. In certain cases, damage is not the adequate remedy, or a specific performance is the remedy. In example is building contracts. Next one is quantum merit. Quantum merit is as much as earned or reasonable remuneration. That is the party entering into contract. In the middle, if they come to know that the one party is not eligible or not having the capacity to do the contract, then the other party can settle the contract with the by giving a reasonable remuneration for the services offered for some 2 or 3 months. That is called as quantum merit. You see, C was employed as a MD in a company. After he rendered services for 3 months, it was found that he was not qualified for the post of MD. So held the C could recover the remuneration for the services rendered by him for 3 months on quantum merit and quit the job. This is called as quantum merit. Then the fourth one is injunction. Injunction is a preventive relief for stopping the persons from doing certain things. When a party is in breach, the court may issue an order to stop him from doing further act. Such an order of the court is known as injunction. There are two types of injunction. One is temporary and another one is permanent. Temporary is a stopping for a particular period. Permanent is stopping permanently from further acts. This is injunction. The last one is damages. Damages is nothing but the monetary compensation. It is allowed to the injured party by the court for the loss of the injury suffered by him by breach of contract from other party. It may be of two types. That is, damages is monetary compensation. It may be two types. One is liquidated and another one is unliquidated damages. Liquidated damage, it is agreed well in advance by the parties, like a penalty or a fine. If you are entering into a bus and you are not taking ticket, you want to pay rupees 500, it is agreed by you in advance. It is liquidated. Unliquidated, it is a damage fixed by the court or the parties at the time of the breach of contract. If the contract is not performed, at the time the damage will be fixed. It is called as unliquidated. It may be of the following types. One is general damages. It is ordinary. What is the loss? You are going to pay. That is general. Special, you are going to pay more than the normal loss amount. Nominal, a very small amount is charged. Exemplary is a very huge amount is charged in the view to punish in the eyes of law by the parties. This is called as remedies for breach of contract. If you are interested in my videos, you can subscribe my channel, like my video, share my video and give your valuable comments. Thank you.